for whatever day you want.
Got someone on Friday, so I just sent him a message.
I don't know if the boss wants to do it on Friday because we usually set it for arraignments. Give me a second. Are you William May?
Yes, Judge.
Mr. May, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present or any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you. I take it that Kavita, you guys are signing on.
If Matt doesn't appoint Michael, we will sign on, Judge.
Okay. All right.
And that's in the works. We've already sent emails to them to let them know that we're going to do the walkthrough prior to today, but we didn't know that today was going to be the day he wanted to do the walkthrough, so I'll handle that.
Because otherwise we're going to have, we have to talk about a lawyer situation regardless, I guess.
Right, we'll be on the case, Judge.
Okay.
Your Honor, complainant and defendant are in a dating relationship and engaged. On June 30th, 2024, officers originally were dispatched to a substation in regards to a meet the citizen call for service. On June 24th, 2024, officers responded to the address with other deputies in regards to a welfare check of the complainant called in by a relative of the complainant. Defendant was arrested for a warrant unrelated to this incident. As they were arguing, the complainant's phone received a notification and she picked it up to see what the notification was. Defendant then reached over and tightly grabbed her wrist and her hand and was holding the phone to snatch it away. Complainant felt pain. The complainant waited to report it out of fear of defendant and or defendant's family getting involved. So it's a late report.
It's not at the same time as the impeding breath, because I see that he's on bond for an impeding
Correct.
breath. Same complaining witness, right?
No, different complainants. Actually, yes. So on the assault impeding, Judge, it was from January of 24, and it looks like
Mr. May and women don't agree. Is that what it is?
it looks like it, Judge. So yeah, the named complainant there is Melissa Thickman, and the named complainant here is Jessica Hess. So different people. They're not related at all.
Mr. May, I'm going to find that there's probable cause to go forward with your case. I'm issuing what's called a magistrate's order for emergency protection. This is a court order that identifies Jessica Hess as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. No one can authorize you to violate this statute. So if Ms. Hess were to call you and say, hey, come on over, let's talk about this, and you go, you're in violation of this, and I don't care who is telling you to go over there. When I mean no contact, I mean no contact from any sources, no phone calls, text messages, smoke signals, Snapchat, social media. Otherwise, I will put you in jail and I will make your bond sky high. I will protect every person of Harris County. I don't care what you say, what you're doing, what your excuses doesn't mean anything to me. You understand? Now, we have to set a bond. You guys have a recommendation.
Yes.
Your Honor, state would actually ask for not a PR bond, actually a $5,000 surety bond because
He has a
was-
felony.
He was out on bond for an impeding DV case, and now he picked up another DV case with a different person. So really, our angle is safety for the community entirely, not just the one complainant or the other.
Let me ask you, in any of these, is alcohol or dope related in any of these cases?
Not on the misdemeanor. Let me take a look at the felony, Judge, just to be sure.
I see that you're representing him upstairs. Have you been so the entire time?
Sorry, Judge.
Have you been representing him the entire time since? Yeah, okay.
That's why we reached out to the MAC, because he wanted me on this case too, but if not, his family will hire us for the misdemeanor.
Okay, sure, of course.
Considering the complainant in this case was in court in the felony, and was trying to talk to me about the case as well.
She wants it split in half. She wants 2,500. You want 5,000.
Sure.
I'll split the baby. So 3,750 it is. You must post bond. I'm issuing a warrant for your arrest now. Looks like Rick, you'll take him.
Yes, sir.
Okay, we'll leave him in your custody then. So 3,750.
States bond conditions or?
Yeah, states. So do you mind filing no contact, no weapons? And then do you want to go ahead and select the date now, even though they're going to go make a bond, or just, right? So Kavita, you're going to post a bond now. They're going to give you a 7-day setting. You're welcome to come back and just get a different date. Now, you have a lawyer, so I will waive your appearance. It is your responsibility to stay in touch with Kavita. She will tell you when you have to come back to court. If she tells me that you're playing games, that you're MIA, not responding to phone calls, text messages, we will issue a warrant. And I'm going to tell you now, you will not get any PR bonds, and I will triple, if not quadruple the bonds if you start acting a fool. Do you understand? Okay. So we will have you go sign. Well, there's no signing. We'll just, I guess, release them to you. First, you must sign your bond conditions, and after that, we'll let you go. Yes. Yeah, I've already spoken. Yeah. So we'll need you to guys sign this paperwork, but after that, you'll have to take a seat while they create their bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? All right. Thanks, Kavita.
Judge, you said 3750.
Yeah.
First.